Yeah, welcome back to ThinkTech. I'm Jay Fidell. This is Life in the Law here in the 4 o'clock block on a given Monday. My brother joins me. His name is Eugene Fidell, and he is a national expert in military justice, having practiced for years and years in that area, having been in the service, and also most recently having taught at Yale Law School military justice for the past 10, 11 years. Welcome to the show, Gene.
Thanks a lot, Jay. It's nice to be back. Currently, by the way, I'm teaching military justice at NYU Law School. I'll be doing that again in the fall.
That's great. Important. And on that basis, we're asking you about military justice at a turning point, the changing role of command. We're going to discuss proposals to change who decides military prosecution for sex crimes and other serious offenses, commissions and bills and discussions in Congress over that. We're going to discuss who picks military juries and whether unanimity should be required. So a very interesting topic, very national topic. But let me preface this by asking Alexa a couple of questions. First of all, we need to know who George III was. That is a fundamental background point for this discussion. So Alexa, who was King George III?
According to Wikipedia, George III was King of Great Britain and Ireland from October 25, 1760 until the union of the two kingdoms on January 1, 1801, after which he was King of the United Kingdom of Great Britain and Ireland until his death in 1820. He was concurrently Duke and Prince Elector of Brunswick-Lunenburg in the Holy Roman Empire before becoming King of Hanover on October 12, 1814.
All right, let me ask you another question. Alexa, what is military justice?
According to Wikipedia, military justice is the body of laws and procedures governing members of the armed forces. Many nation-states have separate and distinct bodies of law that govern the conduct of members of their armed forces. Some states use special judicial and other arrangements to enforce those laws, while others use civilian judicial systems.
All right, Gene, there you have it. Now we really have a sound footing for our discussion. She said some states use civilian systems for military justice. Are we moving in that direction here in these United States?
Well, first of all, let me say this. I think at a future show, you've got to get Alexa and Siri asking questions of one another. They could interview one another. It would be like the barbershop mirror, where there's an infinite regress of pictures.
You heard it here on ThinkTech. Okay.
Right, an exciting new idea. So, well, your threshold question is the United States moving in a direction of what? Moving all military disciplinary matters out of a military justice system and into the civilian courts? Was that your question?
No, but taking elements from the civilian courts and applying them in the military justice system. For example, and if this is the subject of our show, we have military convening authorities who decide, and that will be a military officer who decides who gets prosecuted and what for and when and so forth. Right. But there is a direction on that in which that could change, and we'd like to know, what the environment is in Congress and in the military on that issue.
Right. Well, so the first thing, Jay, is if you plotted the sort of trajectory of military justice over the last really 100 years, you would see an increasing assimilation of military justice to civilian practice. In fact, since 1916, the country's military code at the time was called the Articles of War, clearly indicated that the military justice system should, as a default, replicate or approximate the arrangements in the trial of criminal cases in federal district court, and that's still there. So, our default model is look over to see how things are being done in the federal court. So that's where that leads. Now, the question of the role of commanders is front and center right now. the role of commanders in the administration of military justice. And this question, let me set the stage. In the military justice system, the core issue of who gets prosecuted for what and at what level of severity has always, since 1775, when the Continental Congress passed the first American Articles of War, been vested in commanders, a particular subset of commanders called convening authorities. That is to say, commissioned officers of a fairly high rank with authority to call a court-martial into being, since we don't have standing courts-martial, and send cases to a court-martial for trial. So this is the charging function, what the military calls the disposition function. How should charges be disposed of? And really, until now, that power has been vested in these so-called convening authorities. There are quite a few convening authorities, up to and including the President of the United States. Presidents no longer do sort of retail military justice. If they're properly advised, they avoid getting involved in private individual cases. But because of concerns over the handling of allegations of sexual assault, over the last 10 years or so, there's been increasing discomfort with the arrangements that I just described for the convening authority. Specifically, there's been concern that convening authorities could play favorites. For example, suppose the suspect in a sexual assault case was a valued fighter pilot, and the commander may have individually known that fighter pilot and had a high regard for him or her. Well, does that sort of influence, maybe subtly, maybe not subtly, the commander's decision as to whether a particular charge in a he said, she said situation should go to trial? That's an example. Another example is commanders do get evaluated for the environment within their command. And if it looked like a commander was presiding over a unit that was experiencing a crime wave, well, that commander, might well not get promoted to the next higher pay grade. So the commanders in our competitive promotion system might really be incentivized to sweep some things under the rug at least. So you could see how this is not a perfect system. That's not to say that we have a lot of imperfect systems in human life, but you could see what the concern is. And the concern also was, again, talking about sexual offenses, that in some number of cases, people who came forward, who might be women or men, by the way, were retaliated against for having made allegations, which obviously then dries up the information flow. It discourages people from coming forward with allegations. So this proved to be a very intractable problem, and the military collected data and year in and year out, and the data showed that whatever steps the military was taking, they weren't getting on top of the problem of sexual assault in the armed forces. It's a particularly serious issue, by the way. I'm not talking about the numbers, because the numbers, there's there's lies, damn lies, and statistics. The numbers can be unreliable. And personally, I think some of the numbers may be a little bit higher or somewhat higher than the actual on the ground facts. But be that as it may, the services tried everything, and
What kinds of things did they try?
well,
I mean, this is something, for example, that counsel representing somebody could raise a problem of command influence or some impropriety on the part of the convening authority, and take that up and try
sure.
to handle it through the appellate system. What else might they have done? What else did they do?
Well, a case that never goes to court is a case that the putative victim or the complaining party has no, you can't force in our system. Some other countries have a different approach, by the way, but you typically cannot force the government to prosecute a case. A person who believes that he or she is a victim cannot compel a prosecution. So, that doesn't work. Some of the things Congress did and the services did was create special victims counsel. In other words, they gave some categories of complaining parties lawyers. And those lawyers became more or less active and proactive in representation of putative victims or complainants. I'm cagey about using the word victim. Other people are less cagey, but I'm cagey about it because I don't mean to validate anybody's claim. I mean, until there's an adjudication, the person is simply a complainant. So that's why I'm using that terminology. Congress tried a variety of things. They did endless investigations. They had repeated panels of PhDs and so forth. But the numbers were kind of stuck in a groove. They never really budged. And the services, the service chiefs, the judge advocates general, the so-called TJAGs, would appear before congressional committees, typically on the Senate side, the Senate Armed Services Committee, and they would say, we've got this, and we're doing this, that, and the other thing. And then a year later, there'd be another statistical report, and the numbers would be right back there without any change. So that was very concerning to Congress. And I'll mention particularly two legislators, both women, Senator Kirsten Gillibrand of New York and Representative Jackie Speer of California. These two legislators, one in each house, really took hold of this issue and have continued to drive it substantially. So
Can we define what this issue is? It's
the issue,
the
right,
sexual abuse claim, but you also mentioned that this is, we're also talking about serious offense claims.
Right. So although this discourse, the discussion and controversy that's now coming to a head, and I really think it is coming to a head, emerges from the highly charged environment of sexual assault. Remember the Me Too era that we live in? I mean, this is a big issue for our country, not just people in uniform. The difference, by the way, about the military environment is, remember that it's an official hierarchy. It's a hierarchical and pervasively regulated society where subordinates have to obey as a matter of law. Criminal sanctions attached, have to obey and basically be subordinate to others. And this creates obvious opportunities for overreaching, maltreatment, and so forth. So you can see that, although in some senses it's like the civilian world, in other senses it's very unlike the civilian world. So anyway, although that was the sort of factual context out of which the current controversy, which I'll get to momentarily, emerges, in fact, the sexual assault issues are only an example, a very pressing one, but only an example of a structural problem. And the structural problem is having the charging decision made by somebody who may well have an interest in the outcome. And here I have to go outside our country's borders and look at how other countries have dealt with this issue. They've dealt with it, other democracies, countries with which we're allied, they've dealt with it not only in connection with sexual assault as a phenomenon, and a very concerning phenomenon in the armed forces, but as a matter of achieving public confidence in the administration of justice generally as a structural matter. So you see countries like the UK, whose system, thanks George III, we inherited, abandoned the so-called command-centric system a generation ago. Ditto, and they did that in response to requirements imposed by the European Commission on Human Rights and the European Court of Human Rights. The authorities in Canada made a similar move. They're not subject to the European Court of Human Rights, but as a matter of domestic constitutional law and constitutional norms and values, they reached that conclusion in the Canadian Parliament in Ottawa. Ditto in Australia, New Zealand, Ireland, South Africa, and indeed, as long ago as 1955, Israel, which certainly is a potent military force with, an effective military, had handed the power to decide who should be prosecuted for what and at what level of severity to uniformed lawyers outside the chain of command. And that's the primary issue on the table. Now, related to that is, and this is a $64 question right now, in the United States, the discourse has been prompted by the sexual assault cases. But the issue is it limited to sexual assault cases? And there are people who will say, well, it's a sexual assault issue. We'll deal with it. We'll deal with the sexual assault issue. Or do you say sexual assault is an example of a larger structural problem? And
Well,
we'll
if
deal
that's
with the
what it
structural
seems to
problem.
be, it's a
Yes.
larger problem because it doesn't seem right to just limit it to one kind of case. The
Right.
same abuses, the same kind of lack of confidence could exist in any court-martial case, don't you think?
Yes, yes, exactly. And my own view, and I had the privilege, and I want to digress if you don't mind. I had the privilege of testifying a few weeks ago before the Personnel Subcommittee of the Senate Armed Services Committee. And over the course of my career, I've testified before a few different committees of Congress, invariably as a private citizen. And I have to tell you, it's one of the most exciting experiences because you're just a private citizen. You hold no office. The people who hold office and are sent there by the voters are on the other side of the podium, the lectern, or the witness table. And it's like being in court. And you know this as a litigator. There is an electric thrill to being able to stand at a lectern and say, Your Honors, may it please the court. And ditto, to be able to say, Madam Chair and members of the subcommittee, and then express your view to people who may influence the making of legislation in this country. It's an aspect of the democratic system. Unfortunately, Congress doesn't hold as many hearings as it once did, and the participants are more often not people like me, but people who are kind of vested interests or lobbyists or something like that. But it's a very exciting dimension of democracy. Thank God, touch wood. So anyway, I had the opportunity to testify in this, and I was at pains to say, look, this is the question is not whether we should remove the disposition power away from commanders who are typically not lawyers. In fact, they're overwhelmingly not lawyers, and put it in the hands of uniformed lawyers who are properly trained and are subject to the Code of Professional Responsibility and the usual standards that affect prosecutors. And my submission to the subcommittee on personnel was the principle of the thing seems very clear that that transfer should be made. The question is, what should be transferred? In other words, should it be confined to the sex offenses that have, gripped the popular imagination and gripped the legislative imagination, or should it be other offenses as well? And where I came out is any serious offense. And the classic definition of a serious offense in the United States is the felony misdemeanor dichotomy. And a felony is any offense for which the maximum punishment exceeds a year in jail. whether it's a military type offense, whether it's a sex type offense, or whether it's simply arson. Uh, you know, anything that could land you in jail for more than a year, it does seem to me should be treated as essentially a criminal offense rather than a disciplinary offense. It's not
So
an offense.
what happens though if it's a misdemeanor less than a year or a year or less? That you leave it then with the conventional convening authority arrangement?
Right. In my estimation, that's right. It would be left to disposition by the convening authority with advice of lawyers. I mean, lawyers already play a very significant role. That's one of the funny things here. I mean, if you talk to judge advocates, they will say, well, commanders get legal advice all the time, and so forth. So it's a heavily lawyered process. I don't disagree with that, but at the end of the day, the authority is in the commander, and the sort of logic of the system should track the reality, or the legality should track the reality. And if the lawyer is actually making the decision, then let's have the lawyer legally making the decision. So it's sort of
And let them
interesting.
be separate, let them be independent, let
It
them
should
not
be,
be the
yes.
chain of command. That
That
would be much better than and having a hard-nosed convening authority who actually supervises this fellow in the military or a girl and woman in the military. But let me ask you two questions, Gene.
Yeah.
Number one is the model we're talking about, is it merely the referral of a case to a court martial? Or is it also sitting in the appellate process after the court martial is conducted and somebody wants to appeal or approve the findings or the sentence? Does this lawyer, this non-chain of command military lawyer, does he have any involvement in that?
right. Well, let me, for viewers who have some familiarity with military justice, they may be under the impression that, as in the old days, after a court martial, the so-called convening authority had to approve the proceedings. I mean, that's the way it was under George III, and that's the way it was, for decades and decades, hundreds of years. But over time, and this is quite interesting, over time, Congress has narrowed materially the convening authority's post-trial responsibilities. Once upon a time, it wasn't so long ago, only a few years ago, the convening authority could disapprove the findings of guilt or could reduce the sentence, quote, for any reason or no reason. It was unfettered discretion, and Congress really reined that in materially. So this is arguably somewhat, I would say, substantially less of a change than it would have been, let's say, 15 years ago. Now, what we have is plenty of review after a court martial is finished, after the dust has settled. For sentencing purposes, there's, assuming the sentence is a lawful one, in other words, it doesn't exceed whatever limit the Congress or the president has imposed on the sentence. But if you're talking about the exercise of clemency, that's a different process. That the president can grant clemency, as former President Trump did in a number of highly controversial cases before he failed to be reelected. And the president retains that power because that's in the Constitution. And the pardon power, the clemency power, applies not only to federal convictions in the district courts, but also convictions by courts martial. It's always been that way. And as far as legal issues that may affect a case, we have an elaborate appellate system. Each branch of the service, the Navy and Marine Corps share one, has an intermediate court of uniformed lawyers called the Court of Criminal Appeals that review courts martial. And there's a civilian U.S. Court of Appeals for the Armed Forces. They're civilians, typically with military backgrounds, and they review cases. And to some extent, at least, GIs have access to the U.S. Supreme Court. Although I will say this, and not to change the subject, but one of the things that Congress really has to do is give GIs the same access to the U.S. Supreme Court as every other criminal defendant in the United States. It's a different program, which we can do sometime.
Well,
But
yeah.
but there really is a problem, and for viewers who are interested, there's an article that will be appearing on the Yale Law Journal Forum, an online law review, in a month or so that deals with this. They're really serious problems. Interestingly, only 11% of courts martial ever become eligible for review by the Supreme Court, which is intolerable when you consider that everybody who's being tried down at Guantanamo, all the military commission defendants, and anybody who jaywalks in Washington, D.C., or anybody who litters in Yellowstone National Park can get to the Supreme Court. But 89% of military convicts don't have a right to get to the Supreme Court. Anyway, that's a different subject. But
let me
you
go
asked,
back to
no,
let me
no,
go
no.
back to
Hold,
this.
hold
though.
on, hold on
Yeah.
1 second, because you asked the question: what are the other things that convening authorities can do?
Right.
The biggie, aside from the disposition of charges, the biggie is picking the jury. The military doesn't like the term jury, but they have something called panel members, and they function very much like a jury that we're all familiar with. And in the George III system, the convening authority continues to have power to pick the jury, subject to challenges for cause or peremptory challenges where you don't have to give a reason. That can be problematic, by the way, because race can come into things that way, and that is a problem both in the civilian and the military jury picking process. But for the convening authority to pick the members of the jury is widely recognized as intolerable in the 21st century. So you really have a double whammy. You have a non-lawyer convening authority deciding who gets prosecuted for what and at what level of severity, and you have the convening authority who may not know these people from Adam. Because the convening authority might be a general, and what is he or she going to know about the second lieutenants and the sergeant first classes and so forth?
So in the new model, the
Yeah.
convening authority, the classical convening authority would not select the members of the court.
That's not in the legislation at the moment, but I'm optimistic that when Congress attends to the current bills, which would transfer the charging power, they'll also do something, at least for those cases that do get transferred, whatever Congress decides should be the dividing line. They'll also transfer the jury selection process to some kind of court-martial administrator, like a jury clerk that we're all familiar with from the county court or the local courts. And that, by the way, is the way it's done in other countries that have made this move. I should say common law countries that have a jury system. Most of the world doesn't have a jury system, but we're crazy about juries, even though we don't use them as much as we once did. But we all recognize the importance of jury service.
One of the things that springs out of this is the possibility that the crime will be known to the command, to the classical convening authority, and at some point he or she will have the opportunity to talk to the reference person, the reference officer who refers it to a court martial. And I just one question is a practical thing. Suppose that convening authority says, I'm going to kill this. I am not going to report it to the out of chain of command reference attorney officer. I'm just not going to say anything to him. What happens then?
Well, details like that are going to have to be spelled out in the manual for courts martial. But the problem of sweeping charges under the rug is one that has to be dealt with because of the incentives that I described before. If your command climate is terrible, and the command has an incentive to make everything look great, that's not an
We can't
acceptable
permit
state.
that, right?
That's not an acceptable state of affairs.
Yeah,
So Congress right now has bills that are under active consideration in both the House and the Senate. And here it gets complicated. When he came into office, Secretary of Defense Lloyd Austin, who's a retired four-star general, by the way, who was confirmed with a waiver because there's a statute that says there's a 7-year, I think, cooling off period after you've been on active duty. Essentially immediately established a commission called the Independent Review Commission on Sexual Assault in the Military. And that was a body of highly qualified people. They didn't meet in public. It was a private, internal Department of Defense function. And they were charged with coming up with like a position on this stuff. It unfortunately was cast as having to do with sexual assault, but as I described before, and as I think understand, the issue goes beyond sexual assault. But that was their charter. And they have made recommendations that seem to be oriented towards transferring the charging power to lawyer prosecutors outside the chain of command, independent of the chain of command. That recommendation has not been made public. The precise text of the recommendation, of the precise reasons for the recommendation, have not been made public. The report is under wraps, but it's been provided to the services who have been asked to comment, I think within the next few days is their deadline, and to say, well, what do you make of this? Meanwhile, and in the past, the service chiefs and the judge advocates general have sung in unison on this subject. They've been unalterably opposed to change. Meanwhile, a prior chairman of the Joint Chiefs, Admiral Mike Mullen, Navy Admiral, 4 stars, came out and said he'd thought about it and he thinks the change should be made. The incumbent chairman of the Joint Chiefs, General Mark Milley, 4-star Army officer, the country's top military officer, who figured famously, if you remember, the Farragut Square incident or Lafayette Park incident in Washington, where former President Trump used him as a photo op backdrop, holding a Bible in front of St. John's Church. General Milley has said that in the past he'd been unalterably opposed to shifting the commander's disposition power, but now, now he believes that whatever they've done hasn't worked. So that's what's going on there. Nobody knows what the service chiefs, the chief of naval operations, the chief of staff of the Army, and so forth, are going to say when they come out with their either joint or separate positions. Will there be nuances? Will we have? Will they break ranks? Will there be outliers? Nobody knows. And
has President Biden said anything about this?
Good question. President Biden was asked about this general issue before he took office, and it's my understanding that he made sounds that were quite encouraging. He was asked this by a nonprofit called Protect Our Defenders, a group that has been very active on this subject and very effective on this subject. And I think they asked the same question to all the Democratic candidates, and everybody was making very positive noises. And President Biden said he would immediately have a group look into it, and that, I guess, is what General or Secretary Austin has done. Now,
Gene, we're almost out of time, and I just want to close with one last question. From where we've been discussing this, from where you've seen it, and in your travels and appearances and the like, is there a fair chance this is actually going to be made into law?
Yes, I think there is. To my mind, the biggest issue is not whether there will be this transfer as a matter of policy, but where the boundary line is going to be set between those responsibilities, that category of cases for which convening authorities will remain responsible, or commanders will remain responsible, and those categories of cases for which an independent lawyer prosecutor outside the chain of command will assume responsibility. That's the biggest issue in my mind. But I do think the tide has turned.
Well, that's good. It's a progressive tide, it is. And it'd be good for the military, people in the military, and the view of the public about the military, and therefore the country, public confidence. That's what we're talking about here. Confidence of the troops and confidence of every person on the street.
I want to say one thing, Jay, before you bang down the gavel. Viewers may not realize, but you yourself you were a judge advocate for 5 years in the U.S. Coast Guard, and you were a military judge. Of course, that was during the Spanish-American War, as I recall. But you're not a novice at this. You've been there. You've actually presided over trials. You've dealt with convening authorities. Is there any episode that occurs to you that might be pertinent to this discussion from your own experience?
Oh, there's one that pops right out, and it was the story of a case where I sat as the judge. I made my sentence, and I got a call from the convening authority who had appointed me and who had referred the charges for trial. And he said to me, your decision was inadequate. You should have given a stiffer sentence to this accused, and you should reconsider that and give him a stiffer sentence right now. And I'm sure I told you that my response to that was, "You're out of line, Captain, and don't ever call me again and ever make a request. That is illegal, what you just said." But there's an example of an abuse by somebody who was acting as counsel for convening authority is what it was. And I think this legislation hopefully will cut that off.
It's likely to have a salutary effect.
Yeah. Well, thank you very much, Gene. I hope we can discuss this again, because obviously it's in play and it's important. And there will be things happening, and I hope they are good things. We need good things to happen. Thank you very much, Gene.
Thanks, Jay.
Aloha.